Today we're going to have a look at personal guarantees and what you're actually signing up to. This is one area that we see a lot of damage done to business owners, especially where they bring their spouse into a business or where they're required to sign a personal guarantee as a result of maybe a financial difficulty or bringing new finance to the business. So what ultimately are you agreeing to? Depending on the personal guarantee, you may in fact be giving a guarantee to the entire borrowings of the business without restraint. Now that could be any legal fees incurred in collecting money, that could be any default, that could be any interest payments, it could be anything related to any advance of money, any advance of stock, or any financial obligation of the business. Now, if you think about that for a second, that's a massive financial commitment. And what are you actually getting for it? So if we have a look in the context of a lease, the lease might be 10 years long, you've signed a personal guarantee. You have guaranteed in most cases that lease for the entire 10-year term, including any outgoings and including any damage to the business. Now, you might only be a shareholder in the business, you might be a director, but you may not work in it, but you're fully responsible for that obligation of the business for the next 10 years. So what are the consequences? A lot of people who go bankrupt because of personal guarantees. They've agreed to pay a debt of someone else without necessarily getting anything in return. Now, unfortunately, in a lot of cases, you don't control the business that you've given the guarantee for. Or worse, it's for a business partner and they act in a way that's contrary to the best interest of the business. So signing a personal guarantee is something that requires advice before you do it, and you need to understand what you're signing up to. And worse, we see where parents undertake personal guarantees for their children's business. This is something where things will always go wrong. I don't like to say can go wrong in this, they will go wrong. You've taken an obligation for your children's business without necessarily understanding what you're signing up to. So unless you have control over the business and unless you can take steps to protect yourself, effectively you're handing over control of your financial future to your children. So do you have any control over the personal guarantee? Generally not. Most personal guarantees survive even if the business finance is restructured with the same bank. So generally the only way you are getting out of a personal guarantee for a bank facility is if all the banking arrangements cease. So this means that your business that's given a personal guarantee or to which you are a party to the guarantee could go and borrow some money from, say, the ANZ, pay out the debt, but then get a new loan with the ANZ and you're still responsible for the personal guarantee. They are generally open-ended and not limited. So what should you do before you sign them? Well, simply you need to get advice. Now, the banks require these days for you to get independent legal advice, but it's important to also get independent financial advice to ensure that you know what you're signing up to. And equally, if you are signing a personal guarantee for a business that you're not a controller of, you need to take steps to ensure that your risk is mitigated. Now, whether that is that you take security against a business owner's assets, or whether you have some form of arrangement that ensures that if something goes wrong, you can step in and take control of the business. But if you just sign a personal guarantee without considering what the consequences will be, the financial risks can be significant. So what can go wrong? There's a litany of people who have been dragged through because they've signed a personal guarantee. Generally, these are for their children, the business goes badly, so the parents get dragged in. We see a lot of this for leases, and in one example, we recently had a business owner who sold their business 8 years ago. The business had been sold 3 times after that. The last tenant fell over in 2016, 8 years into a 10-year lease, and then our business owner from 8 years before was forced to pay the final 2 years of the lease, despite not having any control of that business for an 8-year period. This is something that you need to consider. So in that circumstance, what should have happened is they got a release of the personal guarantee. They didn't do that, so they were at the mercy of every subsequent business owner until the final one fell over. So what can you do? Well, prior to signing a personal guarantee, you need to know what assets are at risk. So if you own the family home in your personal name, you need to ensure that you have protections around that. Equally, any assets that you control in your own name should be protected. So this means that if a personal guarantee does get enforced, the financial impact is limited. But equally, you need to know what you're signing into before you sign the personal guarantee. This means you can't rely on people just giving you their word that it will never get called in. You need to be on top of the business that you're giving a personal guarantee for, and you can't merely accept that things are going well. You need to take an active step to ensure that not only are you in control of what you've given a guarantee for, but you're mitigating your risk and you're making sure that it's not you paying for the failure of this business. Now, if you've signed a personal guarantee and you need some advice, or if you're looking to give a personal guarantee for a business, feel free to give us a call on 1300 023 782, or visit our website and book a time to have a chat about what the personal guarantee is and what your risks are. We're happy to walk you through any of the consequences of signing a personal guarantee and what you can do to protect yourself.